Correct.
Okay, on the record, in the matter of the people of the state of Michigan versus Jason Bruce Linton, file number is 23-02876. Appearance for the record, please.
Good morning, Your Honor. Burt Buxton on behalf of the people of the state of Michigan, key number 83466.
Your Honor, Fred Blackman on behalf of Mr. Linton. He's on Zoom and he looks like he's awake.
Mr. Linton, are you okay?
Yes, ma'am. I was trying to hard time this morning. I'm okay.
No worries. It just seems like you're a little tired.
Yes, ma'am.
We love to see you encouraging yourself, though.
Thank you.
Okay, so today was the date and the time set for a preliminary examination. My understanding is that there's an unconditional waiver to the circuit court. Is that accurate?
That is correct, Your Honor.
That is correct, Your Honor.
Okay, was there an offer?
Your Honor, there is no offer at this time.
Okay, and Mr. Linton, do you understand that you have the right to have a preliminary examination here in the district court?
Yes, ma'am.
You understand that the purpose of the preliminary examination is for you to require the prosecution to meet their burden to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You understand that?
Yes, Your Honor.
And do you want to waive your examination in the district court?
Yes, Your Honor.
You understand that the waiver is unconditional. It's not based on any conditions or promises, and you cannot change your mind once this matter is bound over. You understand that?
Yes, Your Honor.
Is anybody making any threats to you to get you to want to waive your preliminary examination?
No, ma'am.
Has there been any promises made to you in exchange for a waiver?
No.
I find your waiver to be freely and voluntarily made. Your bind over date is going to be January 10th. That's the date that the circuit court gets the file from the district court. That's not a date that you need to appear in court, okay?
So I don't have to go to court that day, right?
No, you do not need to go to court on that day. After the circuit court receives the file, they'll set it for a new date. It'll be a pre-trial date. Mr. Blackman will be made aware of that date, okay?
Yes, Your Honor.
So he'll be in contact with you. Do you have any questions at this time?
No, Your Honor. Thank you.
No problem. Bond was set at 4,000 personal recognizance. That will continue. Any additional matters for today's record?
Nothing additional, Your Honor, from people.
Nothing for the defense, Your Honor. Thank you very much.
Thank you. Good luck to you, Mr. Linton.
Thank you, Your Honor.
Happy New Year to you.
Happy New Year to you too.
Thank you. Let's see. On the record, in the matter of the people of the state of Michigan versus Russell Dawson, file number 23-02744. Counsel appearance.
Assistant Prosecutor Peyton Petrosky on behalf of the people.
Good morning, Your Honor. Christopher Coyle appearing on behalf of Russell Dawson, T49708. Mr. Dawson, could you state your name for the record?
Russell Dawson.
And I should indicate that we would, we would consent to doing this sentencing by way of Zoom.
Okay, I would hope so, because you decided on your own to appear via Zoom. Everyone else is inside the court.
Yeah,
okay, so today was the date set for a sentencing. I do have a pre-sentence report. It was prepared on December 20th, 2023. Counsel, did you get a copy of that?
Yes. I've gone over that with Mr. Dawson as well.
Okay. Any reasons to make updates, corrections, or deletions?
No, Your Honor.
Okay, you can make allocution.
Thank you. Your Honor, Mr. Dawson is 45 years old. He has no criminal record of any kind in his past. And I should say that he is a very accomplished and successful professional there in the Lansing area. I don't think it's indicated in the pre-sentence report, but I just want to indicate for the court that He works as an LPL financial representative, which supports the Asteria Credit Union and the Lansing Automakers Federal Credit Union. He's a graduate from Florida A&M University. He has a master's in business administration, and he just received his second master's from Michigan State University in wealth management. He's worked in the banking industry for approximately 18 years and lived there in the Lansing area for just over 5 years. He is a very active in the local community. He sits on the board of directors for the Sparrow Foundation and the Lansing Chamber of Commerce, and dedicates a lot of his free time to philanthropical causes. I say all this to tell you that he is not the typical defendant, if I could put quotes around that we would ordinarily see in the court system such as this. Regarding the pre-sentence report, I spoke with Mr. Sumter at length about it, and both he and I were confused as to after Mr. Dawson was screened for substance abuse, it turned out to be negative for any disorder, which we knew was going to happen. But then the recommendation was for outpatient treatment. So I was going to appear here to suggest to you that Mr. Dawson not have to do that outpatient treatment, but to show you how proactive Mr. Dawson has been, even notwithstanding the fact that it was recommended. He's already done 3 of the 4 weeks that the counselor suggested. So I mentioned that to the court to show you how proactive Mr. Dawson is and how serious he's taking this matter. I want to say this with regard to the facts of the case. I was a prosecutor for almost 30 years in Wayne County. And so I've seen a lot of things, and I've also been involved in a lot of sentencings and a lot of arraignments. And we often hear the word misunderstanding. It's been used a lot, and sometimes we chuckle about that, but I can think of no other word to describe what has happened in this situation than misunderstanding. And I say that very seriously. And the reason why I can say that to the court and suggest that to the court is because given the fact that he was charged with criminal sexual conduct in the 4th degree, I worked very diligently with the Ingham County Prosecutor's Office to arrive at this disposition, which I believe is a fair disposition with regard to the misunderstanding that happened. I think the Ingham County Prosecutor's Office would agree after talking to the complainant or trying to reach out to the complainant in the OIC. That's why we arrived at this particular agreement here. It's then that Mr. Dawson goes and he's interviewed by Mr. Sumter, where Mr. Sumter makes the recommendation that he be on 6 months non-reporting probation. So I'm definitely asking the court to adopt that recommendation. There's just one more thing I'd ask that the court consider. Is the court's aware under Michigan Compiled Law 771.1, this court, if it determines that this defendant or any defendant is not likely to engage in an offensive or criminal course of conduct, and that the public good does not require that the defendant suffer the penalty imposed by law, this court has not the obligation, but this court has the wherewithal or can choose to take this under advisement. And I would suggest to this court that there's no more appropriate situation than this one here, particularly given Mr. Dawson's past in the sense of his accomplishments and the fact of what's happened here, and the fact that there's 6 months of non-reporting probation being recommended, that Mr. Dawson should be, or I ask the court to take this under advisement pending his successful completion of probation, and there at the end of it, no conviction be entered with regard to Mr. Dawson. The last thing I'd like to indicate to the court is oftentimes, if not all times, there's always the recommendation while a defendant is on probation that he or she cannot leave the state of Michigan. In Mr. Dawson's situation, you know that there's been a number of times, I'm sure the court's aware, where we've asked that he leave the state of Michigan while on bond because of some family obligations he has in Florida. He does have another one that's coming up regarding his new MBA, where he has to travel to Chicago from January 23rd through January 28th to get his certified financial planner. He's going to Northwestern University for a week of schooling there. And he does have many clients that are in Florida itself. So I'm asking the court that you not impose the restriction that he cannot leave the state of Michigan. He is tied to the Lansing area and will be back. So with all of that said, I thank you.
Thank you. Can you recite the court rule or the statute that you were relying on as to why you believe that the court would have the discretion to not enter a conviction against him?
So under MCL 771.1, paragraph 1, it states in all prosecutions for felonies, misdemeanors, or ordinance violations, other than murder, treason, criminal sexual conduct in the first or third degree, armed robbery, or major controlled substances, if the defendant has been found guilty upon verdict or plea, and the court determines that the defendant is not likely again to engage in an offensive criminal course of conduct, and that the public good does not require that the defendant suffer the penalty imposed by law, the court may place the defendant on probation under the charges and supervisions of the probation officer, and this would be under advisement. Thereby, upon completion of, or successful completion, I should say, of any probationary term that this court imposes, a conviction would not enter pursuant to this statute.
The prosecution wants to respond to that.
I do, Your Honor. I'll start with this specifically. So while that is in fact the language of the first paragraph of the statute, in the second paragraph of the statute, it states that, you know, this delayed sentencing may happen after defendant has been rehabilitated through the statute specifically lists participation in a drug treatment program. And I just find it a bit inconsistent to first ask that Mr. Dawson not take part in any sort of substance abuse treatment as a term of his probation, and then suggest that his sentence should be delayed because of his supposed rehabilitation when he's already asking to not go through with the steps necessary for rehabilitation. Additionally, I don't necessarily think that it's unlikely that he would engage in this behavior again. If one, he's not going to address the fact that alcohol played a significant role in this assault, and two, if this is supposedly just a misunderstanding, that does not sound like the argument that would be made by someone who understands the seriousness of their actions and thus would be likely to reoffend.
Mr. Quill, do you want to respond? And I also want to give Mr. Dawson an opportunity to address the court if he would like.
Yes. Your Honor, for the very reason why Mr. Dawson took it upon himself to engage, all I'm saying is I just think the prosecutor's misunderstanding or misinterpreting what I'm saying. All right. This is not, I think we can all agree as the three lawyers here that this is not a situation where, given the fact that he tested negative for any substance disorder, then they went ahead and recommended outpatient treatment. We don't generally see that, right? I think we can all agree on that. The outpatient treatment did not fit the reason or why he tested negative. In any event, yes, I would have asked that he not participate in that. However, he did go and participate in it on his own volition, and he still will go complete the fourth and final week of that outpatient treatment. Therein, he fits within paragraph 2 of MCL 771.1, he is showing to the court that he's rehabilitated. His background does show to the court that he's not likely to engage in any criminal offensive conduct. It's not Mr. Dawson who's saying that this was a misunderstanding. It's me that's saying that it was a misunderstanding.
Mr. Dawson, do you want to make a statement on your own?
Your Honor, all I can say is that I never could have imagined by any circumstances that I would be in this situation or sitting here with this happening today. I am happy that I've had the opportunity and happy to finish the fourth visit to substance abuse because I want to learn. And if there was even a chance that there was a disorder, I would not ever discount it. I'm not better than anyone else. I just want to make sure that I'm a good person. I have lots of clients and family that trust me, not just to be a good man, but to be responsible with their business. So I would have never imagined I'm here. I was here, would be here. And really, that's all I'd say. I never imagined I would be here. I do not take this lightly. And I certainly wouldn't use the word misunderstanding, as Mr. Coyle said. That wasn't my word. But if there was any unintended, if something was seen the wrong way, I want the court and the victim to know that I apologize for that. I would have never imagined having a couple of friends over with me to this.
And just for the record, you're not objecting to his delayed sentencing. You're just objecting to, if he's given delayed sentencing, what should be required. Was that correct?
I would be objecting to both. The delayed sentencing was not a part of the plea agreement as it was. This was a criminal sexual conduct case that was pled down to an A and B. So Mr. Dawson is already, I would say, benefiting from that plea deal. And I think that issuing a delayed sentence in this case would be, it's not required by the plea, and two, I think it would be inappropriate given the nature of the case. But if he were to receive delayed sentencing, then I would also be objecting to the requirements that he not take part in some sort of substance abuse treatment. Okay, well, if you're taking the position that due to the nature of the case, it was so egregious that he should have a delayed sentencing, why would it have been pled down to an assault and battery? That's rhetorical, not for you necessarily to answer, just to consider. Because if it was that egregious, it would not or should not have been pled down unless there's some other factors that you had to take into consideration. This was a no contest plea. I read the police report into the record. I reviewed the police report. I reviewed the affidavit of probable cause even before reading the police report. And I tend to agree with plaintiff defense counsel, which is that this is a circumstance that I do believe alcohol played a underlying role. Not that I believe that, based on what I have here, that Mr. Dawson has an issue with alcoholism, but I believe that alcohol played a role, that it was some potentially poor choices made. Based on what I read, not only poor choices made by Mr. Dawson in that incident. I read these facts, at least the facts that was put on the record, and I can see how this was a misunderstanding. Even based on what was stated in the police report by the alleged victim, as to what the third person said, that third person was in shock at what happened based on what the police report states. And that's all I had to rely on for the facts. So there's nothing before the court, not the offer, not the pre-sentence report, not even the report that the court had to use to establish a factual basis that leads me to believe that this would
be a circumstance that Mr. Dawson had not learned from and that he wouldn't put himself back in this position. I would hope not. I would hope that based on what I see here in this report, which is the things that he has worked hard to attain and the things that he's continuously worked hard to attain, and not having any prior criminal history other than some traffic offenses, that he would have a reoccurrence of this type of behavior, or that he has an issue with alcoholism. I don't see that. And I also think that he has taken some effort. I don't know exactly what that's been for him to address some of the classes or the issues that were addressed by Mr. Sumter in the report. And Mr. Sumter again is recommending non-reporting probation. Non-reporting probation, I wouldn't even require him to test regularly. That was the recommendation of probation. So even probation doesn't believe, and it was confusing to me when I read the recommendation. You're asking for non-reporting probation, but then you want me to have him participate in some outpatient substance abuse to deal with some coping skills. And coping skills, I don't know if this was something that he used alcohol for the reason to cope, or he just made a poor decision in a situation where he's in the house drinking with two females in his bed. I don't see how under any circumstance that doesn't create a opportunity or avenue for misunderstanding. You have two females in your bedroom, in your bed with you when you're drinking. That is a recipe for a misunderstanding. Unless you're getting consent up front before they enter your bedroom as to what you think is about to happen, you should more likely than not foresee yourself in this situation. I hope Mr. Dawson has learned his lesson. It's an unfortunate situation. This is an incident where he put his entire livelihood on line for a stupid mistake or error. I don't know if what the victim's perception was what Mr. Dawson's action was. Again, there was a no contest plea, but either way, it was a very poor decision. I think that the recommendation for non-reporting probation is appropriate. I am going to grant the request for a delayed sentence under 771.1. Can you remind me again what he's already participated in as it relates to the substance abuse treatment?
Yes, Your Honor. It was recommended that he do 4 weeks of the outpatient treatment. That's the 12-step program. And he's completed 3 of those weeks, and I think his 4th and final might be next week. Is that correct, Mr. Dawson?
Yes.
Yeah. So he'll have completed it next week.
Okay, I'm going to make that a requirement. It looks like he's been proactive even as it relates to doing that. I don't believe, based on his assessment or his report and investigation, that there is an underlying substance abuse issue. I think the issue is probably stemmed from making poor decisions when you have people that you don't know that well in your home and in your bed, in your personal space. But as you are hopefully moving forward with your life, you've learned from this and you won't find yourself in this situation or any additional situations that places your livelihood or your liberty at risk. The court will adopt the recommendation. The recommendation is for 6 months non-reporting probation. You will complete the 3rd or the 4th week of the treatment course that you've been already participating in, and you'll provide evidence of that to probation upon completion. I will not impose a travel restriction while on the probation. However, I will continue the no contact order with Ivana Ruiz. Do you have any questions so far?
No, yeah.
In addition, there will be fines and costs imposed. There's a $75 crime victim rights fee that will be imposed, plus a $50 state minimum cost that will be imposed. I'm also going to impose a fine of $500. Your fines and costs total will be $625. I'll waive this, any other fees, including the probation oversight fee, as this is non-reporting probation, and the only requirement that I made was that you tender proof of the completion of your 4-week outpatient treatment. Do you have any questions at this time?
No, Your Honor.
There's an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation, and you have the following rights. You have the right to request early discharge from probation once you have completed half the original term of probation ordered by the judge. The probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days from receipt of that notice to file any written objections to your early discharge. You may request an early discharge from probation after meeting the following conditions. You have completed all required probation programming and you have not violated probation in the 3 months preceding your request. You may send a copy of your request, or you must send a copy of your request to the probation officer and to the prosecuting attorney. The prosecuting attorney has 14 days from receipt of your request to file written objections to early discharge. If I schedule it for a hearing to address your request for early discharge, you have the right to hire an attorney. You do not have the right to court-appointed counsel for any hearing for early discharge. Lastly, you may make your request for early discharge by completing the notice regarding eligibility for early discharge of probation. That's the MC 512 form. That form is located on the court website, or you can get it from probation department directly. Do you have any questions so far?
No, Your Honor.
Okay, you'll check in with probation within the next, well, today's Friday and we're closing till Wednesday. You'll check in by Wednesday and then make sure they have accurate contact information with you. They'll prepare an order consistent with my order for you to review and sign, and then you'll be all set. Any additional matters for the record?
Nothing for the people, Your Honor.
Then, Your Honor, thank you.
Thank you and good luck to you both and Happy New Year.
Happy New Year. Thank you.
All rise.
Probable cause conference, Robinson. Aaron Robinson here?
I saw her here.
Okay, her client or probable cause conference is on soon. Let's see, WAC is a waiver. And you said there was a plea?
Yes, I have a plea on Kean.
Okay, you have a plea sheet?
Ms. Wanji just said she gave it.
Oh, it's in the file.
Oh.
Which one is it?
Oh, messed up.
Whose file is it?
For Kean.
I'm gonna go grab him. He's at the jail, good.
I have a restitution form as well. I don't know.
Oh, okay, yes, and then when he gets here, she'll have him do it in vice versa. Okay. Okay, we wasn't sure what we're doing with, Brown variant still.
Oh, we're ready to go on Brown variants.
Are we running an exam?
No, Your Honor.
On the record in the matter of the people of the state of Michigan versus Gregory Brown variant, file number 23-03656, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Gregory Brown Berrien, who is present and standing to my right.
How are you, Mr. Brown variant?
Fine, thank you.
Okay, today was the date and the time that was set for a preliminary examination on police officer assault, resisting, obstructing, and domestic violence. How are we proceeding?
Today, the people would be moving to amend the resisting and obstructing charge to an attempted resisting and obstructing charge, and then ask for a pretrial date for amended.
Okay, and we're dropping the habitual offender notice.
That's correct. Your Honor.
And are you gonna prepare a new complaint?
Yes.
Okay. It will be February 6th at 10:30. February 6th at 10:30. You can appear via Zoom, okay? We'll get you a copy of your notice to appear. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing for defense.
Okay, bond will continue as well as the no contact order, which does include third-party contact regarding the minor child. You're all set, sir.
Have a blessed day.
Same to you. Same to you.
Yes.
Mr. Zaney?
So if he's pleased.
Mr. Zany, can you hear me?
I can, Your Honor.
Okay, are you ready to proceed on your matter?
Yes, ma'am. I'll call you right back.
Okay, on the record in the matter of the people of the state of Michigan versus Ryan Lee Wack, file number 23-03515, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Edward Zane on behalf of Mr. Weck, who's appearing via Zoom with consent. I think he just stepped away, Your Honor. I noticed his face isn't up there. There he, all right, there he is.
Okay, today's the date set for a preliminary examination. Let's see. My understanding is there is going to be a waiver of the timeline.
Correct, Your Honor. So as indicated, today's the date and time for the preliminary exam. I've advised my client of his right to have the exam within 21 days. We're seeking to adjourn the matter out 3 weeks so I can speak with the front office at the prosecutor's office and pursue some additional options or consider some additional options with this case. So he's prepared to waive that 21-day rule.
Is that correct, Mr. Weck?
Yes, Your Honor.
Okay, is anybody making any threats or promises to you to get you to waive the 21-day timeline?
No, ma'am.
Okay, we'll get you a new date.
All right, thank you.
February 23rd at 9. Does February 23rd at 9 work for you, Mr. Zany?
Works beautifully, Your Honor. Thank you.
Okay, we'll reset this matter for February 23rd at 9 a.m. in person at the court. Any additional matters for today's record?
Nothing from the people, Your Honor.
None from defense, Your Honor. Have a blessed new year. Bye.
Same to you. Okay. We didn't find Ms. Robinson. I see Ms. Wanji is here. I think they went to look at Kean, I believe.
Yes, sir.
Okay.
That's his family.
Okay, on the record in the matter of the people of the state of Michigan versus Ronald Bruce Becker, file number 23-02921, appearance for the record.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Becker.
Okay, let's see. Mr. Becker, you can hear us? Okay, you're muted.
Can you hear me now, Your Honor?
Yes, I can, thank you. Today's the date and the time that's
Okay.
set for probable cause conference. This matter is scheduled for a preliminary examination. Or did we schedule it? I think
Yes.
we need to schedule.
We're
I
scheduled.
think we need to schedule it, Judge, because
Okay.
he was in a facility for a while.
We need to schedule this for an examination. Is there anything that we need to address other than that today?
No, Your Honor.
No, Your Honor.
February 29th at 8:30.
February 29th at 8:30.
Can you repeat that again, Your Honor?
No problem. February 29th at 8:30 in person at the court.
Okay.
Do you have any
Okay, Your Honor.
questions?
No, I do not.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Okay, you're all set, sir. Thank you.
Oh, actually, Mr. Becker, can you confirm your phone number for me real quick?
Right now I don't have my phone with me, it's up to my folks's, but I can give it to you if you need it. I mean,
Is it the one ending in,
7-2.
no, okay, so yep, give me the phone number.
989-285-4972.
Thank you.
Yep.
I know Ms. Donnelly stepped out, but was it Grenell that was supposed to be a warrant? Or he has another one? Is that what's going on? Is that Grenell here?
I believe so, no.
I think we need his misdemeanor file if he is. I couldn't find it in the warrant. Warrant folder. It says he has a misdemeanor warrant. Yeah. Okay, so we have Kean here.
Yeah, this
I can't see him back there.
They gave me a date time, but they didn't say, thank you, Your Honor. Next case.
You're free to,
No.
you're free to go, you're free to go, Mr. Becker.
Okay, thank you, ma'am. Appreciate it. Thank you, Your Honor.
No problem.
Sorry, brother. It took so long. That's why I'm not part of the people, man. They're on-
I love that. On the record in the matter of the people of the state of Michigan versus Jerry Kean, file number 23-03205, council appearance.
Good morning, Your Honor. Bart Buxton on behalf of the people of the state of Michigan, P number 83466.
Okay, how are you, Mr. Kean?
Fine.
Okay, today is the date and the time that's set for a preliminary examination, but my understanding is that there's an offer. The people are offering, Mr. Kean, for you to plead guilty to an added count 3 of receiving and concealing 200 to 1,000. It's a misdemeanor maximum penalty, 1 year and or $2,000. And there's a Killebrew agreement of time served. Is that your understanding of the plea offer?
Yes, it is, John.
And did you want to accept that offer today?
Yes, I will, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
That I do, Your Honor.
Thank you. You can put your hand down. It also says here that there's a restitution amount that's owed of $939.95. You understand that?
Yes, I
Are you
do.
disputing that amount of restitution?
No, sir.
You said yes?
Excuse me, you repeat, please?
Are you disputing that amount of
No, I'm
restitution? Okay. I have an advice of rights and plea information sheet. You signed where the date is. Can I put today's date on this?
Yes.
Okay, I'll just date stamp it because you put your signature where it's, the date we're supposed to go, so that's fine. You have your signature twice. I assume this is your signature on both sides, correct?
That's correct, yes.
Okay, did you read this document?
No.
Okay,
Some of it, some
did
of
you
it.
go over the rights with your attorney though?
Yes.
Okay, do you have any questions about any of your rights listed here?
No.
Okay, so the rights that are included on this is your right to a trial. You have the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court any of the witnesses called against you or call your own witnesses to trial or present evidence that you believe further defense to the charge being brought against you. You understand that?
That I do.
You willing to give up each of those rights today?
Yes.
Has anybody made any threats to you to get you to give those rights up?
No, ma'am.
What about any promises? Anybody
None.
promising you anything?
Not at all.
Okay, are you currently on probation or on parole?
No, ma'am.
Okay. You understand that a guilty plea could result in a conviction that you may need to put down on a future job application.
Yes.
You may also need to report this conviction to your current employer. You understand that?
Yes, I do.
And a conviction of this kind could have impact on travel or immigration status that you may be seeking.
Yes.
You understand all of that? Also, there's a Killebrew agreement of time served. That's a Killebrew is an agreement about how you're going to be sentenced. You, Ms. Wangji, and the prosecutor are parties to that agreement. I'm not a party, okay?
Yes, ma'am.
So that means that at the time of sentencing, I determined that I was gonna sentence you other than time served, I would give you the opportunity to withdraw your plea, okay? You understand that?
Right, I do.
Yes.
The plea, I pretty much knew the moped was stolen. It was pretty much obvious.
Well, it sounds like a factual basis. As to the charge, very good, we want you to be honest, and tell the truth under penalty of perjury. So as to the added count 2 of receiving and concealing 200 to 1,000, how do you plead?
Guilty.
Okay, and you said you pretty much knew it was stolen. What city did this take place in?
It was in Lansing.
Ingham County?
Yes, ma'am.
Do you know the area where this took place?
I'm familiar with it. It's right above where I live at, on Pennsylvania.
Oh, it's on Pennsylvania, okay. Any additional factual basis?
The people are satisfied, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. How much time has he served?
I'm not really sure.
Has he been in custody since?
He found out last week,
Last, I'm not sure how many days it was.
last Friday, and he was remanded yesterday
Yes. Yes, ma'am.
on the
Somebody-
on another case.
Yeah. On this one?
No, on his Instagram.
What's his next birthday?
That's the same day.
Oh, okay, he's the longer one? Okay, sounds like you have another matter pending before me, is that correct?
It does.
Okay, I'll give you credit time served, and restitution will be ordered in the amount of $939.95 to a Eugene Mills. Is Mr. Mills here?
Mr. Mills is here. I can go get him, Your Honor.
Just want to know if he wants to make a statement.
Let me go see Your Honor. 1 second.
find the file.
Oh, the other file.
Yeah, it's trying to find. I'll be right back. It's trying to find the file.
For the one that is a warrant, yes. That one.
Your Honor, the victim does not wish to make a statement at this time.
Okay, very good. Any additional matters for the record?
And none from the people, Your Honor. Thank you.
You're all set.
Thank you.
You want to take it back, Your Honor?
Yes, please. I don't see the file anymore. So, are we ready on Boyd? On the record in the matter of the people of the state of Michigan versus Montoya Boyd, file number 23-03071, council appearance.
Good morning, Your Honor. Bert Brooks on behalf of the people of the state of Michigan, P number 83466.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Ms. Boyd, who is standing to my left at council table.
Okay, how are you, Ms. Boyd?
I'm fine. Thanks for asking. How are you?
No problem. Thank you. I'm doing well. Today's the date and the time that is. Today's the date and time that's set for a preliminary examination. Are we ready to proceed?
And the people are ready, Your Honor.
You're ready also, Your Honor.
Okay. Any preliminary matters?
Your Honor, and none from the people.
Nothing from the defendant, Your Honor.
You can call your witness.
All right, the people call Nicole Legion to the stand. 1 second, Your Honor.
And could we approach briefly? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. There's a microphone that's in front of you, and the lady behind you is my court recorder. So she has to take down everything being stated here today. So I need your responses to be loud and clear. You do have good volume to your voice, but these plastic things here can sometimes block sound. If there's an objection from either attorney, you would immediately stop speaking. I'll make a ruling on that objection. I will let you know if you're allowed to give that answer or not, okay?
Yes, ma'am.
Also, head nods and shakes are not sufficient. If you're gonna do head nods and shakes, you still gotta tell us if it's a yes or no for the record. You also can't do or because we can't understand that in the record as well, okay?
Yes, ma'am.
State your first and last name and spell both.
Nicole Leggins, NICOLELEGGIONS.
Very good. You can see, counsel.
Thank you, Your Honor. Nicole, are you familiar with Montoya Boyd?
Yes,
How are you familiar with him?
through one of my best friends, who's her cousin.
Is this Boyd here in the courtroom?
Yes,
Could you please identify her by a piece of clothing that she's wearing?
she has on a black jacket.
All right, thank you. Your Honor, may the record reflect that the witness has identified the defendant.
Stipulated.
Okay, the identification is noted.
Thank you, Your Honor. Ms. Leggins, did you have an incident with Ms. Boyd on July 9th of 2023?
Yes, I did.
Could you please explain to the court what happened on that day between you and her?
Yes. So on the 8th, so earlier in the evening, I was over at an Airbnb where my friend Chantel that lives in Tennessee was here visiting. We were hanging out. Ms. Boyd and her spouse came over. We ended up parting ways. Myself and Chantel ended up going out. We ended up meeting Ms. Boyd and other people at a place on MLK in Logan Square. We ended up going back to the Airbnb. Everybody was just hanging out. I ended up going outside, smoking a cigarette. I came back in. Myself and Chantel's boyfriend were standing in the stairwell having a conversation when Ms. Boyd came. Yes.
This is getting
Can I finish? please?
No, I gave some instructions.
Okay, I'm sorry.
And I said, if there's an objection, you do what? Immediately stop speaking.
Okay.
He's objecting to this becoming a narrative, correct?
That's correct. It appears we're gonna get the whole story with one question, and that's really not appropriate.
Objection is sustained, counsel.
That's fine, Your Honor. I apologize. Let's go back for a minute, Ms. Leggins. You said that this was at an Airbnb, correct?
Yes.
Was that address 427 Seymour Avenue?
Yes.
Was that in the city of Lapeer?
No.
Or sorry, city of Lansing.
Yes.
I apologize. I'm from Lapeer, so I'm still
Okay.
trying to, I apologize for that. All right, County of Ingham,
Yes.
State of Michigan.
Yes.
Okay, so you stated that you had went outside with your friend at this Airbnb, correct? And he was gonna get you to smoke?
Yeah.
And did you run into Ms. Boyd at that time?
When I came back in, yes.
And what happened when you came back inside?
She came from the other side. We were in the stairwell. She came from the other side and asked me who the F I was talking about. And I said, not whoever you are talking about. She thought I was talking about Chantel. We got into an argument and she was asked to leave.
Okay, so did she leave the property at that time?
As far as I know, yes.
Okay, did you have an interaction with her later that night?
Early in the morning, yes.
Okay, can you please explain that interaction as well?
Another friend of mine called me and told me that she was outside. She was looking for the apartment. I went outside, and when I went outside, Ms. Boyd was outside.
So where was she? Was she in the vehicle? Was she on the street?
Standing outside of the vehicle.
Okay. And what did she say to you?
She didn't say anything. She was just standing there. And so I asked her, I'm like, what is the problem? Like, why are we doing this over an argument about wearing makeup?
And at this point, did Ms. Boyd end up confronting you physically?
I came up to her and like, we were face to face like this. And I was like, what is the problem? Are we fighting? Like, why is it getting to this point?
And then what happened after that?
She came at me. She hit me in the face.
Okay. So you said she hit you in the face. What do you remember about that incident?
I just remember like I thought it was initially a punch until I touched my face and I felt wetness.
Was it just you and Ms. Boyd in this altercation?
As far as I know, yeah.
And Ms. Boyd was the one to essentially throw the first punch?
I believe so.
Okay. And do you remember the incident in its entirety?
Yes.
I mean, yeah.
Okay. If you had mentioned in the police report that you had blacked out, could you please explain to the court what that means?
So with the first blow, it was debilitating. It kind of made me like stumble. And then at that point, I kind of like, you know, kind of blacked out, not saying that I like passed out, but just kind of felt discombobulated, if that makes sense.
Okay. And what happened after the fight?
I ran back inside the Airbnb, went into the bathroom, turned the light on, and realized that I had blood all over my face. I couldn't tell like what it was, like what happened. I grabbed a washcloth, put it on there to see what it was, because I thought it was like maybe like a scratch or something at first, and then I realized that it was completely cut open.
What did you do at that point?
I went to the ER.
When you went to the ER, what were you able to figure out in regards to the injuries on your face?
That it was severe enough for me to obtain 30 stitches.
How many scratches did you have on your face?
2.
Can you still see them on your face?
Every single day.
Could you please point them out to the court?
There's one here and then one here.
I'm going to be approaching you as what has been marked as People's Proposed Exhibit 1. Please explain to the court what I've just handed you.
This is a picture of me in the hospital bed.
And that was from that night?
From that morning,
From
yeah.
that morning. And it appears to be a fair and accurate copy of your injuries from that time?
Yeah.
Your Honor, the people request to admit People's Proposed Exhibit 1 in evidence.
The objection.
For the purposes of prelim, no.
People's want to submit it.
Thank you. And if you could please point out to the court in the photos, the injuries.
Do I turn it toward you?
Yes, if you could please point it to the judge.
So here, and then you can't really see it, but right under my eye, which is here.
And you had stated that you had over 30 stitches.
Yes.
How much in each?
I had 7 stitches for the smaller one right under my eye and 23 from here to the bottom of my chin.
And how do you believe that you got these marks?
It's something sharp.
Would it have been from the fight with Miss Boyd?
Yes, sir.
I just want to make it clear. Did you see anything?
I did not.
Okay. To be fair, though, it was pretty chaotic.
Absolutely.
So you had to be here today. Did you call Ms. Boyd saying anything prior to striking you?
Yes. Can you repeat your question? I heard some rustling.
Do you recall Ms. Boyd saying anything prior to striking you?
Yes, there was lots of conversation between me and her at that time.
You and she were yelling at each other?
Yes.
Okay, it would be fair that you can't remember exactly what was said, but you were yelling.
Yes.
Both of you, correct?
Yes.
Okay. You said that she like, when it was like a punch,
I thought it was a punch, yes.
but it appeared to you to be a punch at that time, correct?
Yes.
It didn't appear to be a jab, did it?
No.
Okay, and it wasn't a slashing motion, was it?
I'm not sure. It was dark outside. I seen a hand coming towards my face.
Okay, all right. She didn't say, I'm gonna cut you, did she?
No.
Okay, and she didn't say, I'm gonna stab you, did she?
No.
Okay. You didn't see any knife in her hand, did you?
I did not.
No, it was dark out. Was this outside the Airbnb?
Yes, it was about 2 or 3 in the morning, 3:30 in the morning.
Was it near a street?
Yes.
Okay, was this a Lansing City street?
Yes.
Okay, so was there street lighting out there?
Some, yes.
Okay. The lighting was enough that you didn't see anything in her hands, correct? You could see your hands?
Correct.
Okay. Who all were present outside?
Myself, Montoya, her spouse, and my friend Latoya.
And your friend Latoya? And how far away was your friend Latoya?
She was standing like closer to the street.
In terms of distance, and if you want to use this courtroom to give an example, please.
That Latoya was, where she was at?
Yes,
She was probably where the TV is.
okay. And like a lot of fights, was it drawing their attention, do you believe?
Yes,
Okay, so they were, Montoya was probably looking at you, correct?
yes.
All right. And did you say that Ms. Boyd's fiance was also there?
I believe so. He was inside of the vehicle at one point and outside of it as well.
Okay, and when you were hit, was he outside the vehicle or inside, if you
I'm
remember?
not sure.
Okay,
Sorry.
and how far away was the vehicle from the two of you?
We were she was standing right in front of her vehicle and I was standing in front of her. So if this was her vehicle here, she was here and I was here.
Okay, do you know which hand Ms. Legends or that Ms. Boyd used, was it the right or her left hand?
I don't recall.
Okay. You say that you felt a stinging pain when she hit you?
Yes,
Okay,
it was more of like a burning sensation.
okay. Was it localized to one area?
Yes, it was here.
Okay, and so it was now did you get a deeper cut up higher towards your cheekbone and your eyes?
This is all one. I'm not sure what happened. This was, I feel from the impact of the first blow that this was the first cut or whatever it was that was used to slice my face.
Okay,
The original, I thought was a punch, was here.
okay. You say that you were both punching?
No,
Okay,
I don't feel like there was enough time for me to even react because of the blow to my face.
okay. What was the reason that all the persons got together in the first place?
My friend was here from Tennessee.
Okay, so is it sort of a celebratory get together? Party?
Sure.
Were people using adult beverages there?
Yeah.
Were you using adult
Yes.
beverages? Do you remember what you were drinking?
I had some Hennessy and Coke.
Okay, and what time did the party start?
So I was there at 11 o'clock. We didn't all get back until after the bar. So it was around 2:30.
Okay, and what bar did you go to?
Downtown Lansing.
Okay, and so it started at around, did you say 10:30?
No, myself and Chantel were at her Airbnb around 11,
Around 11, and you got back at what time again?
around 2:30.
Okay, so you started celebrating at the Airbnb and then went to a bar?
I didn't have any drinks until we went out.
Okay. Had you ever had any occasion to fight with Ms. Boyd before?
No,
Had you ever had any bad feelings regarding Ms. Boyd before?
no, I didn't know her other than in passing.
Okay. And you said the subject of the fight was something trivial?
Yes.
What was it?
Montoya came at me about something that I said, which was, I'm glad I'm not a bitch that wears a lot of makeup. She came from the inside of the Airbnb door and started going crazy on me, asking me who I was talking about or her cousin, just being belligerent.
Okay. You had said that she had been asked to leave. Who asked her to leave?
Chantel.
Chantel did? Okay. And she did leave, correct?
As far as I know, yeah.
Okay. You had indicated that at some point you felt you blacked out. When was that?
After the first blow.
Okay, and how long were you out, if you know?
Just probably a few seconds, I'm assuming. I didn't like pass out or anything.
You don't recall whether you were swinging your arms or anything at any point?
I mean, I'm sure I did. After the initial blow, I definitely was in an attack mode to try to defend myself, yes.
Okay.
It wasn't like a all-out brawl, though.
Okay. Did the evening start out badly?
No.
Were you on, as far as you know, cordial, friendly terms?
Yes.
With Ms. Boyd early on?
Yes.
Okay. Was she drinking also?
Yeah.
So virtually was everybody at the party drinking?
Yeah. Can you redirect?
Your Honor, I do not have any redirect at this time. I just asked that People's Exhibit 1 be published to the court. And with that, no further questions, Your Honor.
You may be excused, Ms. Liggins. Thank you. Thank you. You can call your next witness.
Your Honor, at this point, the people would just wish to admit People's Proposed Exhibit 2 into evidence. This is the medical documentation. It is self-authenticating, and I would be admitting it under MCL 766.11B, subsection 1D for purposes of preliminary examination.
Any objection?
No, Your Honor.
Mr. was admitted.
Thank you, Your Honor. With that, the people rest, Your Honor.
Is the defense calling any witnesses?
No, Your Honor.
Argument.
Yes, Your Honor, we believe that we have met the probable cause standard, and we ask that you bind over on the charges in this complaint. In regards to count 1, Ms. Boyd is charged with the charge of assault with intent to do great bodily harm less than murder. In regards to this count, you heard from the victim today, Nicole Legends, that she was attacked by the defendant, her friend's cousin, Ms. Boyd, on the night of July 9, 2023 at 427 Seymour Avenue in the city of Lansing. Your Honor, you can see the wounds in People's Exhibit 1. This is not a mere scratch from a punch between two individuals. From the picture, it is very clear, and from the medical records as well, the defendant has a slash on her face. This is a exact but deep wound on her face. If Your Honor would like, under the jury instruction 17.7 for assault with great bodily harm less than murder, it states that great bodily harm means a physical injury that could seriously harm the health or function of the body. The instruction also states that you may consider the injury to show the intent for causing great bodily harm, but actual injury is not necessary. Your Honor, wounds that deep and large on a defendant's face is clearly great bodily harm and shows that the defendant wished to do great bodily harm onto the victim, Ms. Legends. As Ms. Legends stated, as you can see in the medical records admitted in People's Exhibit 2, the victim needed 30 stitches to get this stitched up. There were 2 lacerations on her face, the largest being 22 centimeters, Your Honor. The scratch was no mere accident. We have met our burden in regards to count 1. In regards to count 2, felonious assault, we believe that there is circumstantial evidence to believe that a weapon was used in this case. The people will agree that the victim did not see a knife in this matter, Your Honor, but it does not mean one was used. I understand that the victim did not see a weapon, but most people don't go looking for a weapon in an individual's hand, especially a friend of a family member, when they start a fight, Your Honor. Furthermore, if you look at the actual wounds on her face, this is not a wound that can be just caused by a fingernail, just caused by a punch. These are long, precise, and deep wounds on the victim's face. And you can still see that she had scarring to this day while looking at her on the stand, Your Honor. This is clearly caused by some type of sharp instrument of some kind. Therefore, we believe there is circumstantial evidence to show that there was a weapon used in this case to assault Ms. Legends. We believe that we have proved probable cause in count 2 as well, Your Honor. So we ask that you bind over on both charges. Thank you.
Mr. Silverfield.
Your Honor, maybe 30 minutes, and you just heard all the testimony. The court knows I'm really brief. I will simply and have a general request to deny the bind over.
Thank you. Today was a date set for preliminary examination. The purpose of the preliminary examination is to require the prosecution to meet their burden of probable cause. So they need to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. I have a felony complaint here that charges you in count 1. with assault with intent to do great bodily harm, less than murder or by strangulation. And then there's a count 2 of assault with a dangerous weapon, also known as felonious assault. And so this is not a trial. The prosecutor does not need to prove each element beyond a reasonable doubt. Today, the burden is more than mere suspicion that a crime was committed. The court will be the sole determiner of credibility of the witnesses, and the court also weighs the government's probability of establishing guilt at trial. I had testimony today from one witness, that being the alleged victim, Nicole Leggins. She stated that on or about July 9th, 2023, at the area of 427 Seymour, City of Lansing, Ingham County, State of Michigan, that she was there for a celebration at an Airbnb with a friend from out of town. That's the person she identified in the court, Montoya Boyd, was present, and that they engaged or interacted at some point at the Airbnb. They left, parted ways. The victim stated that they later met up at Logan Square and then returned to the Airbnb. The victim stated that she went outside to smoke, and when she came in, that she encountered an interaction with the defendant, whereby the defendant asked her, "Who the F are you talking about?" The parties got into an argument. The defendant ended up leaving, or they parted ways again. Later on, early the next morning, this actually being the July 9th date, the previous incidents occurring on July 8th. On July 9th, early morning, the victim states that she was notified by another person that the defendant was outside waiting for her. The victim exited the house. They interacted by exchanging of words and asking her, "Why are you acting like this?" At which point the victim states the defendant hit her in the head or in the face. The victim believed it was a punch until she felt something warm and wet on her face. She said she blacked out, not losing consciousness, but disoriented. She later noticed, when back in the home, that her face was open a bit. She was bleeding. She did report to the Sparrow emergency room and was treated with over 30 stitches. The People's Exhibit 1 is a photograph of the victim with a gash. I believe the longer one being 22 centimeters long. Looks like it extends from just below her hairline down to the jawline, and the gash I can see through to the flesh. There's blood over her shirt. There's a smaller gash right near her eye on the left side. The People's Exhibit 2 being a copy of the medical health record. Count 1, assault with intent to do great bodily harm, less than murder or by strangulation, requires the prosecution to prove at trial beyond a reasonable doubt, first, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause the injury, or at least believed that she had the ability. And then third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there is an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. In this case, we have a testimony that there was an injury caused by Ms. Boyd, and that the result of that injury being two gashes or open wounds that required stitches on the victim's face. This incident occurred in July. It's now almost January, and as the victim sat in the witness stand, the court could see the wound still apparent. As well as the court was able to review the exhibits. Based on that, the court is satisfied that there's sufficient probable cause as to count 1 to bind over assault with intent to do great bodily harm, less than murder or by strangulation. Count 2 is assault with a dangerous weapon, that being a felonious assault. The prosecutor has argued that although there was no weapon that was recovered, that circumstantial evidence could be used to support support probable cause that a weapon or a dangerous weapon was used. I'm looking at the injury that was caused, and obviously it is a deep gash that required some stitching up a little bit deeper at the end. I do not believe that's a gash that could be caused with a bare hand. I would agree with the prosecutor that if one were to suffer that kind of interaction and injury, they wouldn't stop to go and look for the necessary weapon or device used. I think that there is a sufficient circumstantial evidence based on the evidence presented as to the injury to support charge 2, that a assault with a dangerous weapon was used, in that there was assault upon a Nicole Liggins with a weapon, that being a knife or a similarly sharp-edged implement. With that being said, count 2 will be bound over to the circuit court. Bind over date is going to be January 10th, 2024. That's not a date that you need to appear in the circuit court. That's the date that the circuit court will get the file from the district court, okay? Okay? Okay, your next court date will be a pre-trial in circuit court. You do not need to be rearranged in circuit court, okay? You'll stay in contact with your attorney. He'll be made aware of your next court date. Bond was set at $3,000 personal recognizance. There is a no contact order in place for the protection of Nicole Liggins. You're not to be within 2,000 feet of wherever she is. You're not to have contact directly or indirectly with Ms. Liggins. Bond will continue, as well as the no contact order. Any additional matters for the record?
And no, Your Honor, thank you.
No, Your Honor.
Thank you. You're all set. You can get your exhibits.
Thank you, Your Honor.
No problem. I'm not sure, is Ms. Donnelly in your courtroom?
She is.
Oh.
I'm waiting on one reason why on Cassidy.
Okay, perfect. I just want to make sure.
Thank you.
It's
It's gonna be a plea.
Yes.
We can bring Cassidy up.
Thank you, Your Honor.
No problem. And Mrs. Cirillo stepped out, I think.
I'm still looking for, well, last time I was gonna get her records from St. Lawrence Hospital in regards to her prescriptions. I have finally gotten that release of information request out last week with
you
all
just
of
need
these.
more time?
What's up?
You just need more time?
Yes, ma'am.
February 29th. February 29th at 9.
February 29th at 9. Okay.
What's going on with Grenell?
Your Honor, for Grenell, we do have an offer that I want Mr. Grenell wants to consider, as well as I want to talk to Ms. Petrosky. So we would be waiving the 21 days and having this set for a plea.
Okay, where is Mr. Grenell?
He's right here.
On the record, in the matter, the people of the state of Michigan versus Tyler Steven Grenell, file number is 23-03666, council appearance.
Good morning, Your Honor. Barb Buxton on behalf of the people of the state of Michigan, P number 83466.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Tyler Grenell, who is present standing to my right.
How are you, Mr. Grenell?
Good, how about yourself?
I'm doing well, thank you. Today was the date set for a preliminary examination in this matter for receiving and concealing vehicle. And my understanding is that there was an offer extended. Is that correct?
That is correct, Your Honor. The plea offer in this matter will be to a added count 2 of joyriding, which would be a 2-court high court misdemeanor, as well as a additional count 3 of receiving and concealing $200 to $1,000. We would also be dismissing other retail fraud cases that Mr. Grenell has as well as part of a global resolution.
Okay, and so because you want time to consider that, you're willing to waive the 21-day timeline, is that correct?
Yes, sir.
Okay, you do understand you have the right to have your preliminary examination within 21 days of the date that you're arraigned?
Sure.
Okay. Anybody threatening to get you to waive the timeline so that we can reset this?
No, Your Honor.
Any promises being made to you if you waive the timeline?
No, Your Honor.
We'll reset this matter. For a plea, yes. And January 11th at 9 a.m. is your new court date. You make sure you appear for court, okay?
Yes, ma'am.
Because you did not appear on December 4th on file number 23-01958. Why is that?
So you have a misdemeanor.
The retail fraud second, I'm assuming is probably one of the ones they're considering dismissing in this matter.
Yeah, so you had a failure to appear on December 4th.
No, I don't have any excuse for that.
I think it's, is it still warrant status, Your Honor?
That's why I'm addressing it.
Well, I bonded out on it, when I was on.
Well, that you brought it out on this new case. They haven't.
Yeah, we didn't put you on tether for the retail fraud, but we did see you on October 30th. This matter was reset because the councils were trying to work out a global resolution. We gave you that date of December 4th at 9:30. But then you let us down on December 4th at 9:30. We didn't see you. Okay, so I recognize you that you say you don't have any reasonable excuse. You make sure you're in contact with your attorney, Ms. Donnelly, or whoever else is representing you on this. It may be Mr. Lee. They'll always try to give you a call if they don't see you in court, but you need to make sure you're keeping up with your court dates, especially if you have more than one thing pending, okay?
Sure.
Okay, so this matter will be reset for a plea on January 11th. We are going to quash the warrant on the retail fraud, and it sounds like we need to set that for a pretrial on January 11th. Yes, I'm doing that just because it's part of the global resolution. Oh, sure. All right, any additional matters for today's record?
None for the people, Your Honor.
No
Thank
for
you.
defense?
Okay, we'll see you on January 11th, sir. Who is this, Mr. Cassidy?
Yeah.
Yeah, I should be in your.
Thank you.
That'll be up in a minute with the advice.
Who you got?
Order and Briggs.
Thank you.
Yeah, he's gonna have two, because he has two cases.
What's that case number? Yep.
Gotcha. Gotcha. Don't text me like. I was just saying. That's just about to say.
Okay, on the record in the matter of the people of the state of Michigan versus Sean Cassidy, file number 23-01066, counsel of here.
Good morning, Your Honor. Bart Buxton on behalf of the people of the state of Michigan, P number 83466.
Good morning, Your Honor. Assistant Public Defender Stephen Feigl, said on behalf of Sean Cassidy, who's standing to my right this morning.
How are you, Mr. Cassidy?
Not bad, yourself?
Doing pretty good, thank you. Okay, today's the date that was set for a preliminary examination on one count of stolen property, receiving, concealing motor vehicle, and count two, stolen property, receiving, concealing less than 200. I see that there's an offer extended to you, Mr. Cassidy, for you to plead to count two, and that the people will dismiss count one. Did you want to accept that offer?
Yes, I did.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. This is an advice of rights and plea information sheet. Is that your signature?
Yes, it is.
Okay, did you read this document?
Yes.
You understand each of the rights listed here?
Yes.
Do you want to give these rights up in order to plead guilty to count two?
Yes.
Okay, you understand that you have the right to proceed to a jury trial and you have the right to the presumption of innocence. So you're innocent until proven guilty, and you have the right to require the prosecutor prove your guilt at a trial by proving each element of the charges being brought against you beyond a reasonable doubt. You understand those rights?
Yes, I do.
You also have the right to remain silent at your trial and not have silence be used against you. You have the right to confront in court any of your accusers and cross-examine them, and you have the right to call your own witnesses or present evidence that you believe further defense to the charges being brought against you. You understand those rights as well?
Yes, I do.
Are you willing to give up each of those rights today?
Yes, I am.
Anybody threatening you to get you to do that?
No, ma'am.
Has there been any promises to induce you into pleading guilty and waiving your rights?
No, ma'am.
Are you currently on probation or parole?
No.
You understand that a guilty plea could result in the conviction that you may need to report to either your current employer, or you may need to put this conviction on a future job application.
Yes, I do.
This conviction could also have impact on travel or immigration status that you may seek in the future. You understand that?
Yep.
As to count two of stolen property, receiving, concealing less than 200, how do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Factual basis.
Yes, Your Honor, Mr. Cassidy, I want to turn your attention back to March 30th of 2023. Were you at 314 Allen Street?
Yes.
That's here in the city of Lansing?
Correct.
Needham County, state of Michigan.
Yes.
Whether you ran into law enforcement from the Lansing Police Department, is that correct?
Yep.
In relationship to there being a traffic stop, is that correct?
Correct.
I guess there were still plates on the vehicle, is that correct?
Yes.
And the cops asked you some questions about that, is that correct?
Yes.
And you had in your possession a key fob to a car, is that correct?
Correct.
And you may not have known it was stolen, you had reason to believe or should have known that that key fob that was given to you was taken from somebody else and not with permission, is that correct?
Yes.
There's no additional questions for Mr. Cassidy.
Any questions from the prosecutor?
People satisfied, Your Honor.
The court is satisfied with the factual basis, and I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. Let's see, was there any restitution on this?
There's no restitution at this time, Your Honor. We would leave it in reserve just in case we would actually need some time to contact the victims for a sentencing, Your Honor, if we could put this out just a couple of weeks.
They weren't here today for exam?
They were not, Your Honor. I was told that we'd be doing the plea yesterday, so we did not bring the victims in.
But my understanding is I'm not sure if they've even had contact with the victims at this point, or I don't know that.
I'm sorry?
I'm not sure if they've had even contact with them this week.
Based on what you're saying, it doesn't sound like they did unless they called them today or yesterday and told them not to come.
And Your Honor, we took their name off the calling list. I apologize. It does not look like our offices had any contact with the victims, but I would ask for a brief adjournment so we could.
Well, I'm glad because there's a victim, I am gonna set it for sentencing. Sentencing is going to be. I'm not referring him though. January 11th at 9 a.m.
So good, should make that work, Your Honor. I'm standing in for the
Okay, sounds good. And so I'm not sending you to be, I'm not referring you for pre-sentence report at this time. My inclination was to sentence you to time served because I think you were remanded back on the 7th. Is that correct? However, that's just my inclination. If you don't come to your next court date, that inclination is likely to change, okay? Okay, so what are you gonna do at your next court date?
I will be here.
Thank you. Okay, so your next court date again, January 11th at 9 a.m. You can appear via Zoom if you have the capability of doing so with video, or you need to come in person, okay?
Okay.
Okay, and then by then we'll find out if there is going to be restitution or not. Any additional matters for today's record?
None from the people, Your Honor. Thank you.
I would just ask for Mr. Cassidy to get a PR bond this morning, Your Honor, given the reduction in charges. He's given insurance to be here, Your Honor. He will be here. If the court's inclined to place a tether on him, allow him out, I think it's sufficient.
Bond is set in the amount of 500 personal recognizance, and we'll see you at your next court date.
Thank you.
Thank you.
Thank
you.
You have a seat, right here, we do your bro.
Okay, so we need, let's see. On the record, in the matter of the people of the state of Michigan versus George Richard Davis, file number 23-03658, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Dwayne Silver, the Office of Public Defender, on behalf of George Davis, who is seated at the council table to my right.
How are you, Mr. Davis? You said not so good? Anything in particular other than you being in custody makes you not so good?
Having manic episodes and minor strokes, and then trying to contact the CMH doctors to get more information about what's going on.
Okay, so you're having some medical issues?
Yes.
Okay, well, hopefully they'll get in contact with the CMH doctors and get you the treatment that you need so that you can do better, okay?
Yes.
Today was the date that was set for a preliminary examination. Are we going to be continuing to exam today?
No, Your Honor, it's my understanding that defendant will be waiving his case up to the circuit court and the people will waive it. It has the case be found.
Mr. Silverthorne.
That is correct, Your Honor. Negotiations will continue up the circuit. Yeah. There you go. Yeah.
Oh, those are just about my office.
Oh.
Okay, we ready to proceed?
Yes, Your
Oh,
Honor.
okay, sounds good. Okay, so Mr. Davis, do you understand the purpose of the preliminary examination?
Yes.
Okay, so the purpose is that you have the right to require the prosecutor to put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with those crimes. You understand that?
Yes.
Do you wish to unconditionally waive your preliminary examination? Do you want to have an exam?
But the sign.
No, I didn't ask you about anything about signing. I wanted to know if you want to have your preliminary examination here and require the prosecutor to establish probable cause.
Don't waive it.
I know what your attorney just said to you, but I want to know what you want to do.
Yeah, I want to go to circuit court.
Okay, you want to go to circuit court? Anybody threatening you to get you to waive your examination?
No.
Any promises being made to you if you waive your examination?
No.
And you understand that the waiver is unconditional, you can't change your mind, you understand that?
Yes.
Okay. Yes.
May I briefly add to the waiver given his initial reluctance?
Yes.
I went downstairs and talked to you in the jail, correct?
Yes.
And I explained to you more specific reasons why we were gonna waive and why it would be in the best interest, is that correct? And I explained to you how I intended that to handle the matter in the circuit court.
Yes.
Correct? And based upon all of that, you today agreed to waive the exam. Is that correct?
Yes.
When the judge initially asked you, were you just maybe correct?
I just got kind of confused when she said the exam part. I know this preliminary exam, but I got confused when you said exam. I know I was waiving the circuit court.
Okay.
But that's a choice and decision that I made to do.
Okay, very good. Okay, very good.
Thank you for allowing me.
No problem. Thank you for clarifying the record. Okay, the bind over date's going to be January 10th. That is not a date that you need to appear in court, okay, sir? That will be the date the circuit court gets the file from the district court. Your next court date in circuit court will be a pre-trial. Mr. Silverthorne will be made aware of that, okay?
Okay.
If you have any questions for the court?
So if waiving it today, this would just be the end of the court for today. It won't be anything else.
You won't have any other court dates today, and you won't have any other court dates in this case in district court.
Okay, yes.
Okay, you understand that? Okay, and then your bond was 75,000 cash surety. There is a GPS tether requirement as well that will continue. Any additional matters for the record?
Nothing further for the people, Your Honor.
Nothing for the defendant. Thank you.
You're all set. You running Carter?
People are prepared to run Carter. So it was my understanding that we would be running it.
Okay, and then what's going on with Larson?
Your Honor, Larson might be a plea. I talked to him downstairs and he indicated that he might be taking the offer that the prosecution's offering.
We'll bring both up. Okay, on the record in the matter of the people of the state of Michigan versus David John Larson, file number 23-01841, council appearance.
Assistant Prosecutor Pete Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant David Larson, who is present and standing to my right.
How are you, Mr. Larson?
Pretty good, Your Honor. How about you? How about yourself?
I'm doing pretty good. Okay, let's see what's going on in this file. I have a preliminary examination and a bond violation hearing.
Yes, Your Honor. It's my understanding after speaking with defense that we will not be holding the preliminary examination today, as defendant will be, or it's likely going to be accepting a plea offer in this case.
Oh, this is an old bond violation, correct?
Yes.
There's two on the docket today.
Yes.
Maybe they didn't put it in the file because this one says August 23 on it. It looks like there must have been one in December.
Your Honor, like I said, there was a PA 53, a first violation. It's both two violations for his tether. So one in August, we had it set for a hearing, and Mr. Larson failed to appear. And there, in the meantime, there was a second violation. So
Yeah, I don't have that one in my file for some reason. We have an advice of rights.
I have not had him filled it out yet, Your Honor, because it was my understanding that we still need to get him screened for domestic. The offer is that he goes to Ward's domestic violence court.
Oh. It needs to be screened.
Yes, Your Honor.
So we need to set this.
Yes, my understanding is we need to set this for a plea and sentencing. We don't mind setting it out just a week or so, just as soon as possible.
Ready for January 5th and 9. January 5th at 9 a.m. Okay, so the offer was for him to plead guilty to an amended count 2. I'm gonna take it to added count 2.
There were 2 counts already on the file, Your Honor, so it'd be an added count 3.
Added count 3. Added count 3 of aggravated domestic violence. If the people will dismiss count 2 of domestic violence and a misdemeanor case in 55th.
Your Honor, yes, in that case, it would be dismissal if with amended count, or with added count 3, they would dismiss 1 and 2. And the 55th.
My apologies. I thought
No.
amended counts instead of just adding.
Don't worry, yeah,
I can refill out the form.
My understanding is your office for first added, is
Okay.
is what my understanding is. Let's see, there's a Killebrew offer to either a Killebrew of no upfront jail and domestic violence court, or no sentencing agreement. Is that accurate? Okay. And so he'll be screened. We'll set this for a plea on January 5th at 9 o'clock in the morning. Any additional matters for today's record?
Nothing for the people, Your Honor.
Your Honor, just from the defense, only that Mr. Larson, when he was taken in on the warrants, he was remanded without bond. He has been in custody for 17 days. We would be requesting that some sort of cash or money bond would be set. Thank you, Your Honor.
People would be asking that bond remain as is, given some information that from the victim, excuse me, about contact potentially being made between defendant to the victim while he's been in jail. There's concerns about further contact if he were to be released. And that information has been shared with the defense.
Your Honor, I believe that if there's been allegations that he's been breaking the no contact in jail, then it doesn't really matter if he's out or in. But in that case, like I said, we're not asking for a personal cognizance bond. We just asked for some sort of money bond.
So, bond will be denied because originally there was a 10,000 cash surety bond, and then there was been multiple violations of that bond, including failure to appear and issues with GPS tether. I have 2 bond violations pending for cutting off tether. With that being said, you'll be remanded to your next court date. Any addition, and let me also address the allegation that there's been bond violations related to contact with the protected party. There's a no contact order in place that says you cannot have any contact with Renee Garza. That's contact directly, that's third party contact or indirect contact. You understand what that means?
Yes, sir.
Okay, it's also contact from the jail, which is reported. You understand that?
Yes, sir.
Okay, and you can't even try or shouldn't even try to use someone else's PIN number while in jail because they'll still find out. You understand that?
Yes, sir.
It's a bond violation. That's a contempt of court order. The maximum penalty is 93 days in jail and $7,500 in fines. You got an extra $7,500?
Okay.
Okay, so you probably don't want to violate.
No.
You want to spend the first 93 days of January 2024, or the first 90 days of 2024 in jail?
No, I don't.
Okay, so I'm going to remind you of the no contact order. You make sure you remain in compliance. Your next court date is next week. So we'll see you next week. Any additional matters for the record?
Thank you.
None for defense.
You're all set.
Yeah, just have a seat right there.
We're ready with Carter or no? I'm gonna bring him, oh, he is here.
I think we're ready. Yeah.
On the record, the matter of the people of the state of Michigan versus Devon Carter, file number 23-036668 FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Devon Carter, who is standing at council table to my right.
How are you, Mr. Carter?
Fine.
I'm doing well, thank you. Today's date and the time that was set for a preliminary examination. My understanding is that we're ready to proceed. Any preliminary matters before we call the witnesses?
Nothing from the people.
Nothing from the defendant, Your Honor.
You can call your first witness.
The people will be calling Mr. Chase Edwards.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, you can have a seat. Okay, there's a microphone that's in front of you. You probably want to remove your gum while you're giving testimony. Okay, there's a microphone in front of you. The court recorder is behind you. She has to take down everything being stated here today, so your responses must be verbal. They must be loud and clear. You can't do head nods or shakes or mm-hs and uh-hs, okay?
Yes.
If there's an objection from either attorney, you would immediately stop speaking. I'll make a ruling on that objection, and then I will let you know if you can give us that answer or not, okay? Can you state your first and last name, then spell both of them?
Chase Edwards, CHASE EDWARDS.
You can proceed, counsel.
Thank you, Your Honor. Good, well, I guess good afternoon, Mr. Edwards. How are you today?
Okay,
So, where were you on December 9th, 2023?
I was at home, 2003 Elizabeth Street, Lansing, Michigan.
Is that in Ingham County?
Yes,
What were you doing?
I was working on my truck.
And did something interrupt that?
Yes, my neighbor had came down and advised me that my motorcycle was being stolen.
And what did you do?
I asked him where they were at, and he pointed and told me to hop into his car. So I hopped in the car and rode with him to
And so your motorcycle was gone.
Don.
Can you describe your motorcycle?
It's a white dirt bike. It's street legal.
Okay. So you then went in your neighbor's truck or your neighbor's car?
Neighbor's car. We went around the corner where he seen the gentleman pushing my bike. And
Did you said that he saw the man pushing your bike? Did you also see the man pushing your bike?
I was under my truck working on it at the time that it was stolen, so I didn't see the bike. Watched them walk by his house and then got in his car and came and got me.
And what's your neighbor's name?
I believe his name is Alex. Okay. That was the first time I had met my neighbor.
Did you eventually see your motorcycle?
Yes, so we go around the block and we seen the motorcycle and a car following the gentleman pushing the motorcycle.
And do you know what street about that was?
That was off of Marcus in an alleyway headed towards Kalamazoo.
It's still in Lansing, Ingham County?
Yes.
In Michigan. So, did you give the person who was walking the bike, did you give them permission to use your bike?
No.
Did you want them to have your bike?
No.
And what did you do after you saw the man with your motorcycle?
I asked my neighbor to call the police, and he advised me that he doesn't speak English. And I didn't have my phone on me because I was out working on my truck, all unexpected. So I got out of the vehicle and pursued the gentleman pushing my motorcycle.
Your neighbor, Alex, did he tell you that he didn't speak English in English?
He said not much English.
Okay. So what, you said you began running after the man with your motorcycle.
Yeah.
What did the man do?
He turned and looked at me, and then he threw the motorcycle down and started running towards the vehicle that was its followed vehicle.
When he turned and looked at you, were you able to see his face?
Not.
Yeah,
Because
that's fine.
it was dark and
Yeah.
had some different.
So you said he dropped the motorcycle and started running away?
Yeah, he looked back threw the motorcycle down and just started running towards the car.
Can you describe the car?
It was like a black SUV.
So the man was running towards the car?
Yes.
What did he do after he was running towards the car?
He jumped in the passenger seat.
And what did you do?
I pursued the vehicle on my motorcycle. So after the gentleman dropped the motorcycle, I picked it up. And my key was in the ignition, so I started it. And by the time I got my bike upright and started, he was already in the vehicle. So then I started to follow the vehicle.
How close did you get to the vehicle on your motorcycle?
I got right next to the driver's door.
And what happened when you were driving next to the car?
I seen a passenger pulling out like a long rifle from in between the seat and the center console.
And what happened next?
I tried to hit my brakes and just to get out of the way because I knew I was going to get shot at. So the passenger got up out of the window and pulled the rifle out and started shooting at me. And then I had to crash my motorcycle because we were in an alleyway.
Yeah.
And I couldn't go left, couldn't go right. So I just had to go down to get out of the way.
So when you saw the gun, you said it was a long rifle?
Yes.
What color?
Black.
Did you know what type of gun it was besides just that it was a long rifle?
No, I didn't know what kind of rifle it was.
Okay.
To my knowledge from the first, how close they were together, it could have been like a hunting bolt rifle or something, but it wasn't a shotgun.
Okay, yeah.
So,
And you said it was shot in a burst?
yeah, there was about 7 shots right back to back.
When the gun was being shot, where was it pointed?
Pointed at me.
Where was the man looking when he shot the gun?
At me.
Could you see his face?
I could see that he was pointing the rifle in my direction, aiming at me. So I was not looking at a face.
Understand.
I was looking for a way out.
Yeah. Where was your neighbor, Alex? Where was he at in relation to you or in relation to the other vehicle?
So from my understanding, I crashed my motorcycle and I picked it up and was trying to leave the alley. And my neighbor was right behind me in his vehicle. So I told him to turn around and go because they were shooting.
When the man was shooting at you, was the vehicle moving?
Yes.
What was going through your head when you were shot at?
Just how they get out.
How were you feeling?
Scared. I guess I was just in shock, not really knowing what to do. Never been shot at before or anything like that. So I was just trying to get out of the way of the gunfire and go home.
Either when you saw him walking or when you saw him lean out of the car, were you able to see what the man was wearing?
The guy that was pushing the motorcycle, I believe he was in darker clothing and possibly some boots. And then the driver, I got a little better look at, and all I could see was like some dreads or plaits or some kind of longer braided hair.
So after, your vehicle or your motorcycle crashed and everything, what did you do?
I got up, I started it, and I went the opposite direction that I was previously going. And told my neighbor to turn around and go because they were shooting. And then I took my bike straight back to my house and grabbed my cell phone and called the emergency services.
Did you speak with police?
Yes.
Did you provide them with the description of the man who stole your motorcycle?
Yes.
Did you provide them with the description of the vehicle they were driving?
Yes.
And then just to cover my bases, it sounds silly. When he fired the gun at you, was he in possession of a firearm?
Yes.
And he was in a car at that point?
Yes.
No further questions.
When you were chasing this vehicle, and he was shooting and the shooting started, how close were you to the vehicle?
I would say probably from me to that wall away.
And where was your neighbor at the time?
I'm pretty sure that he was maybe just turning on to the alley behind us.
Well, why you say you're pretty sure? Are you not certain where your neighbor was at?
I'm not certain that where he was at that time when they started shooting.
Okay. And you had to tell him that they were shooting?
When I got up after I crashed my motorcycle, I advised him that they were shooting, but he already knew that they were shooting. He thought that I was dead when I fell down.
Okay. When you had recovered your motorcycle, it was operational, is that correct?
There's damage, but yes.
It was damaged when you got it?
It was damaged after the crash because I had to crash to get away.
I understand that.
So yes.
When you recovered motorcycle, at that point, had it been damaged?
I'm not sure because I would say yes, because the guy threw it on the ground to run away from me.
But it was operational, correct? You got it up and you were able to drive it, correct? Okay. You didn't know who took it, did you?
No.
You didn't know the person was armed, did you?
No.
You're not law enforcement, are you?
No.
Why did you go after him?
Because I wanted to protect what was mine and see who was stealing the thing.
Okay. But you had already recovered what was yours, hadn't you?
Correct.
It didn't occur to you that someone stealing something might shoot at you? What's the distance that you traveled on your motorbike from the time you recovered to the time you pulled up in your testimony almost next to the vehicle?
Not even an eighth of a block.
You said not, you said an eighth of a block?
Probably not even it was 2 or 3 house lengths.
Okay. 2 or 3 house lengths? Okay. You said that the firearm was pointed at you? Okay. Did you get hit anywhere?
No.
Did your bike get hit anywhere?
No.
Did you see any damage beyond your person, like to a building or anything?
No.
Okay. Did you see the muzzle flash?
Yes.
Okay. Did you feel bullets go by you?
I feel like, yeah, maybe I heard a couple bullets go in.
Okay, but you're not sure?
Not sure.
Okay. And you indicated that you were from yourself to what, the far wall in this courtroom?
Yeah.
All right. Was the shooter's face concealed from you at all?
I can't answer.
You don't recall seeing the shooter's face?
Recall seeing the shooter's face.
Okay. Did you recall seeing the person pushing your motorcycle?
No.
Did you recall seeing the person pushing the motorcycle discard the motorcycle?
I guess could you clarify?
Discard would mean not push it anymore. You said throw it down.
Yeah, I seen the guy throw it down and get in the car and then get out of the passenger window and start shooting at me.
Okay. What time of day was this?
This was at like 6 p.m.
Okay, on here in December?
5 or 6 p.m. in
Okay.
December. Yeah.
Was there any lighting where this occurred?
Very little.
Did the person that shot at you say anything?
No.
You didn't hear a voice, is that
No.
correct? Did the person that was driving let's call it the getaway vehicle, did you hear that person?
No.
Did you see that person?
I've seen a little bit of that person.
And you indicated that you thought that person had dreadlocks, is that correct? Yeah. But you don't have any other description? Did you get a license plate number?
No.
You got just a general description of the firearm?
It had an Indiana plate. It was a black SUV. My bike got stolen and I got shot at and I had to crash. That's what happened. That's what I was paying attention to. That's what was going through my mind at the time.
Okay. It happened very quickly.
Yeah, so I don't get shot at on a daily to know to look for all these things or to try and pick somebody's face out or.
Sir, no one's being critical of you. So I'm just asking questions. Had you spoken to this neighbor before this incident?
No.
Where do you keep your motorcycle parked normally?
Normally I keep it parked right up against my porch and my house.
Okay, and is it locked as a rule?
No.
Okay. And where does the neighbor live in relationship to you?
Up around the corner. At the end of the block.
And you had never spoken to him before?
Never.
How long did you own the motorcycle?
I've owned a motorcycle for a year.
Okay, and I take it is titled in your name, correct? Okay. We just have a few more questions. Did you have a cell phone on you?
No.
And I'm sorry, I think you had mentioned that you did not. You were upset that your bike was being stolen, correct?
Yeah.
You didn't like someone stole it, did you?
No.
Okay. And that's why you went after the person, correct?
I wanted to see who was gonna take my things, yeah.
You said, I wanted to see the person you take, had you been losing other things in the area?
Yeah.
What other things?
The day before, actually, it was probably a week prior, somebody tried to break into my neighbor's fence to steal a bike and they couldn't get it through the rungs. So then they came back 3 nights prior and ripped the whole fence down to get the bike.
So,
and I've also had bikes stolen before from my property, from inside my gated area. So yes, there has been a lot of riffraff going on around my house.
and you were hoping to, maybe if you could apprehend the person, prevent future thefts?
I wasn't trying to apprehend anybody. I was trying to get a look at who was stealing my things.
Just got a couple questions for you. So I think between the two of us questioning, detail might have gotten a little bit unclear. So when the man was pushing your bike, did you at any point see the man who shot at you pushing your bike?
Yes,
So you saw him actively pushing it?
he was actively pushing my bike with the follow car following and the getaway car following him.
And then you saw him just throw your bike on him?
Yes, so we got to the end of the alley at Kalamazoo Street and took a right, and the car went out on the road, took the right, and the guy pushing the motorcycle cut through the Kristen's yard right there on the corner. That's when I hopped out of the neighbor's car and ran up and said, "What the hell are you doing with my bike?" And he looked back, threw it down, and ran. I picked my bike up, started following the vehicle. They turned right down an alley in between Hayford and Magnolia, headed towards Marcus. And then that's when I started getting shot at.
And you had said you usually store your motorcycle outside?
My motorcycle is normally stored in my garage, but I had just gotten home and I was working on my truck. So I got home from the parts store and pulled my bike up to my normal park spot. I parked my bike right up against my house and my porch. So my one handlebar is touching the siding of the house and the whole front tire is all the way up against the porch. And it's off.
When it's parked like that, is your bike visible from the road?
Yes.
Did you speak with your neighbor after, like immediately following the shooting?
Yes.
How did he say how he was feeling?
Scared.
Did he say why?
Because he was the one that informed me of my bike being taken, and people taking the bike looked right at him and said that's his fault.
No further questions.
You made this witness be excused.
Yes, ma'am.
Thank you, Mr. Edwards. You may be excused. Call your next witness.
Thank you, Your Honor. The people will call Mr. Alex Koenig.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Excuse me?
I don't understand.
Doesn't understand English.
Yeah, so
You can take it back outside. I think you need to have an interpreter. What language, sir?
Spanish.
Spanish, thank you. You'll have to have him come back with an interpreter.
I will, and my apologies, when I spoke with him on the phone, I was under the impression that I would be able to conduct the examination today, and then
Were you able to have further communication with him
it
in English?
was limited, but yes.
Okay.
And so when I spoke with him this morning, he said that he wanted an interpreter. I said, okay, it's a little last minute. And so he had agreed to try and proceed with the examination. And then if we ran into problems, then I was going to ask for adjournment for interpreter.
Okay. Well, he doesn't even understand the oath. So on top of that, based on the testimony of the previous witness, he doesn't speak English. So I think we need to get an interpreter to be safe. And so were there any other witnesses today?
I have one of my officers.
Okay, you can call your next witness.
Should I send yes, thanks.
Apologize. Mr. Koenig says he would be able to give testimony today in English. So
He's gonna get an interpreter.
Okay, I'll let him know.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. You can have a seat. If you can state your name, first and last, and spell both.
Officer Kristen Brown, Tristyn Brown.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer Brown. Where do you work?
I work for the Lansing Police Department.
And what are your duties?
Patrol officer. I answer calls for service. I can run traffic.
Were you working as a police officer on December 9th, 2023?
Yes, ma'am.
And did you receive a call from dispatch that day?
Yes.
And what was that for?
It was for a weapons complaint. Dispatch advised that there was a possible UTA in progress. They shot at a couple people, and so I responded to the area and attempted to look for the vehicle.
Okay. And when you got to the area, the general area that you were dispatched to, did you observe anything notable?
I was in the surrounding area. Officers called out a possible accused vehicle, and I was right around the corner, so I assisted with the traffic stop.
And where was that stop taking place?
I believe it was on East Cesar Chavez, right in front of the liquor store there.
And is that in Lansing?
Yes.
Ingham County?
Yes.
Michigan? So when you arrived, officers had already made contact?
Yes, I was the second unit that pulled up. Due to the severity of the crime, possible load firearm in the vehicle, subjects had it and my gun at the load ready. We conducted the felony stop. Officers took out the driver first, and then they proceeded to get the passenger out. Once
I'm gonna stop you there, then we'll go through a little slow. Thanks. So can you describe the vehicle that was stopped?
I can't at the top of my knowledge right now, but I just know it was silver. Silver and
Mr. Silver, what?
Like a silver van, SUV kind of.
Like a bigger vehicle?
Yeah.
Can you describe what the occupants of the vehicle look like?
There were 2 subjects, 2 black males. I know the passenger was wearing a black hoodie, and I believe the driver was also wearing a black colored shirt, black clothing. Possibly match the subject that dispatch advised us that occurred the incident. So.
And did you have to make contact with the occupants yourself?
I was covering officers while they were getting the occupants out of the vehicle. So I was just my main focus was on the vehicle. When the driver was out, I still had eyes on the vehicle and the passenger at the time, and then officers ordered the passenger out. And
And when you say secured, what do you mean by that?
Detained them until we got the vehicle secured or vehicle cleared. There's no other occupants.
And why were you clearing the vehicle?
Just make sure there's no other occupants in the vehicle. We didn't with the felony stop, and due to the severity of the crime, we had to just make sure the vehicle's clear of any occupants before we go any further.
And why do you need to make sure it's clear by occupants?
Because possible firearm that any occupants could have had, and so we just wanted to. We had to make sure that the vehicle is clear. There's no anybody that could possibly have a firearm on them or that type of vehicle.
When you were clearing the vehicle, did you see anything notable?
Yes, we cleared the vehicle. Me and officers observed a larger AR pistol on the passenger seat floorboard. In the front, the barrel was sticking out. So the barrel would be sticking towards the door from that side.
Okay. Did you and you said that was the front passenger?
Yes, front passenger floorboard.
Did you at some point examine the firearm more closely?
Officers already they were taking it, so other officers took it for evidence. And so when I was writing my report up at the jail, after we arrested, I observed it more closely, and the serial number scratched off. There was no stock. There was only a bump or two, and I know this because I was in the military for 3 years. So
You know this because of what?
I was in the military for 3 years, Your Honor, and so I know.
You have experience.
Yeah, experience with firearms. Yes.
And you said the serial code was
Yes, the serial number was scratched off.
Scratched off.
It was on.
Do you know if the gun was loaded when it was seized?
When we observed the vehicle, I did notice a magazine in the magazine well. I don't know if I didn't clear the vehicle or clear the firearm. I didn't have the firearm, but I did observe a firearm in the magazine or a magazine in the magazine well.
And then at some point, did you speak with or encounter the man in the passenger seat, like face to face?
Yes, when I was transporting him to the jail.
Okay. And would you recognize him if you saw him?
Yes.
Is he present in the courtroom today? Can you describe where he's located in the article of his clothing?
He is sitting right there with the darker blue clothing on.
Let the record reflect first that Officer Brown pointed towards the defendant with his hand, and then also that he has identified the defendant.
Any objection to identification?
Not for the examination.
Identification is noted for purposes of freeloading.
Oh, I guess I should have asked as well. Did you get the names of the occupants of the vehicle?
I remember, I believe the driver was Hickson and then the passenger was Devon Carter.
Wait, who was the driver's name?
I can't remember the first name, but the last name was Hickson.
Hickson.
Any further questions?
Cross-examination.
You indicated that the serial number was scratched off. Could you tell how long it had been recently scratched off, or?
I haven't.
And you have no idea who scratched it off, is that correct? And as between the passenger and the driver, you have no idea if they had any connection to that other than it was in the vehicle, correct?
From my knowledge.
You don't have any personal knowledge of the theft itself, is that correct?
No.
And you said that the vehicle that you stopped was silver in color?
Yeah, it was like a silver in color, like Van SV. I can't remember the top of my
I always think of gray as a bit little darker and silver being a little lighter. Was this a little bit lighter colored vehicle?
It was nighttime at the point, so it could have been gray or silver, one of the two.
Okay. It was not a black vehicle?
No.
Was not a navy blue vehicle?
So,
It wasn't like a real dark red vehicle?
can't remember. No.
Okay. Did the driver passenger resist being taken out in any manner?
When we were doing the felony stop, no, I did not. So the driver or passenger just.
Did you have any responsibility for like obtaining fingerprints, say from the motorbike or anything like that?
No.
So there is no forensic evidence that you took, is that correct?
I did not.
Okay. And in terms of cartridges retrieved, that was not your responsibility either?
Not my responsibility. Other officers' responsibility.
Thank you, officer.
Redirect.
No redirect.
Thank you. Officer, you may be excused.
Thank you, Your Honor.
Thank you. Any other witnesses today?
No more witnesses today, right?
And it's your intention to recall, was that Mr. Koenig?
Yes, that was Mr. Alex Koenig.
Oh,
And then I also was informed that Officer was Christopher Clue. My apologies.
Christopher Clue.
Clue. I found out this morning that he was on a family vacation. So I would he also would be being called to testify.
So we'll continue this matter so that Officer Clue can return from his vacation. Do we know how long he's on vacation?
I don't, Your Honor. I found out, I think, third or fourth hand that
Okay.
he was on vacation. So I don't
Sounds good. And then we just need to arrange for a Spanish interpreter for Koenig. I believe. Prosecutor's office. Prosecutor's office will. I'm sorry. Prosecutor's office will arrange for a interpreter for Mr. Koenig. The soon was February 1st at 9. February 1st at 9.
January 1st?
February.
February 1st?
We're closed January 1st. And 2nd. Okay, so this matter will be continued until that time. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing from the attorney, Your Honor.
You're all set.
So one other one won't file. We can, one and file, we can do that.
Yeah.
No, I didn't want to file, we do that.
I think so.
And we got to file. We do, so. All right, it's yours.
And he said certain words.
Yeah.
Better have it.
Which makes
More
better,
and more.
I mean, I would rather have it later, but yeah.